I will not cut too long in the coffee breaks, but I had one question to Professor Reiner, actually, two remarks. First of all, thank you very much for your presentation, which I found very enlightening. I'm from the Netherlands, and that's that part I would like to deal with on 2 points. As you correctly stated, the current Dutch Civil Code has a stratified, so-called layered approach. But then you said that the good faith provision only applies to real rights. And I think you have used the wrong translation, because if you look on the site of Dutch civil law, you see indeed, Book 3, property rights. However, in Dutch, it is vermogensrecht in het algemeen, which means patrimonial right in general. So it means both the law of obligations, it covers both the law of obligations and the law of property. So if you find something in Book 3, like the good faith requirement, it applies to all of the parts, also the other patrimonial fields, inheritance law. So it is not only in good faith. And the second point, just briefly, is about the number of articles in our transport part, Book 8. I always compare it to the Inuit, the Eskimos, who have a great many names for different types of snow, because it's essential for their survival to distinguish what kind of weather it is. And we, the Dutch, we are very much dependent upon transport. 50%, over 50% of our national income is actually coming from transport, import, export. And I think that is how it can be explained as well, that we have so many articles, so many provisions on transport law. But first, I really enjoyed your presentation. Thank you very much.
Yeah, thank you very much. I think the Dutch Civil Code, for my thinking, is a very important example of the variety, because it shows that there is a civil code which is based on a very, let's say, detailed description of, it was not a criticism, but only to compare. And it is, of course, a richness. Yes, as far, let's say, my very feeble and weak critique is, I thought you have a third book, and of course there you find the definition, even if it's the whole of patrimonial rights, but it's not structured in a way than other codes would be, who would have a first book, a general book, or first, or let's say, norms, general norms at the beginning of the code. On the contrary, also Austria do not have a general definition of good faith at the beginning of its code. So you are not alone. And about definitions, well, one can discuss about it. And as I told you, they are useful if they are flexible. If they are not flexible, they're not useful. But for me, the existence of the Dutch Civil Code is a very good example. I'm thankful that it exists, because it shows that variety is very useful. I don't think that but it's my personal opinion, and as not being a Dutch lawyer, but let's say I'm very close to Myers. I read a lot of what he has written, also in the Dutch language. But I think your actual code is not the code of Myers. It's not the code Myers would have, let's say, intended to write down, let's say. But there's other aspects. And if I may just add a very, very small thing, I spoke about private law and civil law. about commercial law and so on, we must never forget an outstanding example of a very particular approach to the question of private law, and it's the Swiss one. The Swiss one about the law of obligation on the one hand side, which is civil and commercial, and then the civil law book. This should never be forgotten that we have a third way, and it's the Swiss one. And again, if I mentioned in the history of codification Eduard Meyers, of course, Eugen Huber, the Swiss codificator, was an outstanding lawyer. And again, as Meyers was also, Eugen Huber was was excellent in writing. This way, he was first the director of a famous newspaper. And that's the reason why, for me, language has always a big importance. I don't know how you do it in Hungary, but for me, I think, and that's the point, codification, you can't do it from today to tomorrow as a simple act. Codify would mean, and here's one who knows it very well, Hugh Beale, who again is an excellent example of how important wording is, and the beautiful, let's say, finding a beautiful text, as Hugh Beale for many years in the group for von Bahr had done. That's to say, because we others in the English language, of course, do not have his, are not so perfect. You know. But he was all, I remember you very often, your points when it came up to writing the text, a real text. And so, and that's the reason why a codification will always exist. That's to say, lawyers, judges, professors, and so will always try to amend codes. We'll always think about it, and they can't do it in one day. But thank you very much for your on the Dutch Civil Code, which is an important example again how important variety is in codification.
I would like first to thank all three panelists. It was really, really interesting. Unfortunately, I have now to change my presentation this afternoon. But I would like to ask one, perhaps to the last speaker, to address my question to the last speaker, to colleague Josipovic, because it is something which really interests me. It's perhaps a question of legal theory, of legal philosophy, actually, of course, of general part of the civil codification. You have mentioned very numerous exceptions of the private autonomy. What is actually in I think, when research, what do you think about it? When research about this basic principle, in order to conclude what is really remain of this principle. This principle is so limited in all its aspects, so that I ask myself, is it principle anymore? What do you think about it?
So, thank you very much for your question. You have right. I think that today, perhaps we, not only on national level, but on EU level, perhaps there is a need for a new definition of private autonomy. What does it really mean? Because a lot, it's interesting in fact, because a lot of these rules in EU law that limit private autonomy, as we understand this private autonomy on national level, the aim of all these rules is to enforce private autonomy for one contract party, for consumers. So, in fact, to put consumers in position to enforce informed decisions about conclusion of contracts. And I think that this traditional notion of private autonomy we had when we started to reform our law in 90s is completely changed. And that a lot of our colleagues, when we talk about changes in national law because of EU law, are very, very critical. They said, no, it's not okay because it's against freedom of contract, private autonomy. But I think that we have to be aware that this old concept of private autonomy is totally changed, and that we need perhaps to make one comparative research how to define it now in new circumstances. Specifically now, I had no time to talk about that in digital, on digital market. On digital market, I think that this traditional private autonomy is even more limited than when we are talking about consumer contracts on EU level.
So thank you for your speech, and maybe about this private autonomy, the tendency or the trends, the new trends is to create less space for private autonomy because we are unable to be responsible and to sanction bad behaviors. The justice is not efficient. The state cannot provide good service in justice. And we are not able anymore, it's a little bit exaggerated, but maybe we have a real problem with effectiveness of the rule of law, and better way to solve this problem today is to create limitations for the private autonomy, and we should maybe pay attention about all these limits that come from authorities that are not elected. It's not a democratic wish to every time have dispositions, many laws. In France today we have 44 million words from national law, only national law in force. It maybe should be a question, why only technocrats are dictating so many interdictions, prohibitions. It should be a question, in my point of view, in a democratic space of freedom.
You know, I think that something what is also visible when we are talking specifically about consumer contracts, it's sanctions. In fact, we have a lot of public sanctions in our Consumer Protection Act, and this is something what is also, in fact, in line with EU law, because EU member states are obliged to regulate effective remedies, and these remedies are more or less public sanctions, monetary penalties. But I am not sure that this approach is in fact really effective in practice. We have a lot of rules on penalties for traders if they do not behave in line with all these mandatory rules, but it's impossible to apply all these penalties in all cases. You know, I think that it's nice to see in the law the national state fulfilled the obligations in line with EU law, but it's quite impossible to apply all these rules against each trader who did something wrong in some contract relation. You know, I think that perhaps this is on the end, I think that a lot of us have, in the moment, very idealistic approach to private autonomy, and we have to be aware that this private autonomy from 19th century, from beginning of 20th century is dead. It's not the same relations, social relations, reasons for regulation of a lot of private relations are so different now that I think that there is a really need to find a kind of middle approach and to define the private autonomy on a different way. I must say, for example, when we reformed our property law, one of the biggest problems was how to regulate management of condominium. And we on the faculty, we were in this group, and we said there is no need to regulate management of condominium because co-owners will decide by themselves how they will manage their building because they have interest to manage their building on the best way. And after a few years, we realized that we were totally wrong. That if there is no mandatory rules for co-owners how to manage the buildings and what to do to improve the buildings, that it will be totally ineffective. And on the end, the consequence of this very liberal approach we had 20 years ago is that we had earthquake 3 years ago in Zagreb, and that a lot of buildings, because of very bad shape, were destroyed because there were no specific rules, mandatory rules, public rules to improve the management of the buildings.
Thank you very much, and we heard very interesting presentations, and my question would be to all of the presenters being here, and starting with the presentation regarding Italy, that what is actually happened related to the non-pecuniary damages was a modification of the code by the courts. And this is also a question to Professor Attila Meinhardt, that you saw actually the civil code much more as a flexible tool to guide the judge instead of you compared for the administrative regulation, which is a totally different one. But this how far can go with this interpretation. Also, the judge, when establishing the content of a norm, there is a limit where this interpretation must stop or not. And so that would be my question, because time is limited.
Yeah, thank you very much. My question will be on his one. And again, thank you very much to all three speakers. But let's say my ideas are also on Professor Meinhardt. That's to say, you mentioned Walter Wilburg, and this was an excellent idea. He was one of the most interesting lawyers, not only Austrian lawyers of the 20th century, and having studied first in Austria and then in Berlin, there he became what we could say a comparative lawyer. That's to say, his ideas are deeply rooted in comparative law, and his flexible system, das bewegliche System, you mentioned it, is exactly the point, and here the question, that it is in a certain way gives the judges the opportunity to interpret in a more or less stricter way. And this depends now on what rules do you have for interpretation. And so I said, the Austrian Civil Code is not so well known around the world, but it has some very interesting aspects, as very concrete rules as far as interpretation is concerned. So these rules, together with the flexible system of Walter Wilburg, are, at least in my mind, a guarantee for the existence of codes, both the rules of interpretation and the flexible system. And so I would just to add, and not to ask you, but to just to ask you to reflect on it in the next years. Thank you very much.
So thank you for your question. Actually, in Italy, civil liability has become a judge-made law, Richterrecht, especially in the field of non-pecuniary damage, compensation for non-pecuniary damage. Because of this general clause, I think I can define this constitutional principle as a general clause, which is contained in Article 2, and which is specified from point of view of protection of health in Article 32. So this general clause has been interpreted by the jurisprudence in subsequent evolution, in subsequent historical context. And of course, this has led to significant modification of the interpretation made by the judge about the limits of compensation for non-pecuniary damages. From this point of view, we can also talk about a judge-made law which has been modified by a subsequent judge-made law. It is quite interesting from the point of view of codification and of evolution of the codification. That's why I thought to dedicate my speech, my presentation to this aspect, especially from in the evolution from Supreme Court judgments of 2008 and the Supreme Court judgments of 2018, there has been quite a significant evolution, because 2008, our Supreme Court didn't accept the idea of loss of amenities of life, so what we call existential damage, danno esistenziale. In 2018, our Supreme Court affirmed that actually from the point of view of loss of dynamic profiles of personality, there could be a place also for existential damage. Actually, in 2018, Italian Supreme Court utilized a slight different word, that is damage to relation life, danno alla vita di relazione. It's a bit difficult perhaps to translate it. From this point of view, again, I think that there has been actually a judge-made law in progress, so to say, which has been continued, which has faced the continuous evolution, also from the point of view of the role played by punitive damages. I just devoted a couple of phrases to the problem of punitive damages. There has been, I said it again, I said it already, a very important judgments in 2017, which opened the Italian system to punitive damages in certain limits. For example, the punitive damages must be foreseen by, disciplinated by a previous law and so on. But there is an open space now also for the sanctioning function of civil liability. I hope I have answered to your question. Thank you.
Thank you. I will be very brief. I think we could start now a very long-lasting discussion. And I just want to give some kind of impression to you, to both of you, to your question. The first is just to this reference to Walter Wilburg. He used the tort law to describe this system, and I think it's an important factor, because if we turn to tort law, the fundamental concepts of it, like fault, causal link, compensable loss, unlawfulness, they are such a wide concept that they can't be interpreted themselves. So even if there are some kind of rules, doctrines generally accepted or rules provided in the Civil Code for interpretation, it doesn't work because they are to be established by the court. I think that also holds for unjust enrichment, which was also the other area Walter Wilburg used. I think I tried to give you an example for contract law, but I see the fundamental concepts like those ones about the binding force of contract, and I don't know, changes of circumstances. Okay, there is a rule that there is a change of circumstances or hardship that can make the contract unenforceable. But there are no even guidelines. Perhaps there are some guidelines provided for that, but they are just guidelines to do that. That doesn't mean that the court can't give some more examples for this. And also the concepts like the mistake or the juror's misrepresentation or unconscionability are such a wide one in all of our jurisdictions, I mean, anyhow we structure them, that one cannot use a kind of method of interpretation for that because they simply give the authorization to the court to apply a kind of policy, what they want to reach. I don't mean that all of the rules or all of the provisions of the Civil Code have the very same quality, because in a Civil Code there can be very clear-cut rules. I mean, if there is a time limit for, I don't know, 5 years, 10 years, a court is not authorized to say that it should be less or more. That's not what I mean by that. But even if a provision of the Civil Code is such a concrete one, there are still the general clauses, which mean that if there is a general clause that rights and obligations should be performed and exercised according to the requirement of good faith and fair dealing, as an algorithm is just like giving a rule somewhere in the Civil Code and saying that you have this right, except it is against the good faith and fair dealing. That means that, according to my view, there is a general authorization provided to the courts for that. If it is a satisfactory reaction, I don't mean it's an answer or anything.
Thank you very much. I just would love to add some element for this passionate debate about the limits or the liberty that has the judge to apply law. I think one of the elements to understand the real problem that day-to-day life is observable, can be seen in the courts is the cultural element. For example, in France we have this system, and it was what Portalis would love to have. Portalis said in his discours, l'office de la loi est de fixer par des grandes vues les maximes générales du droit, établir des principes féconds en conséquence, et non descendre dans le détail des questions qui peuvent naître sur chaque matière. C'est aux magistrats et aux jurisconsultes pénétrer de l'esprit général de loi à en diriger l'application. And I come from this citation, by quoting this part of the discourse, to the creative role of the judges. It's a real question today in France. We know that everywhere. But I think, as I told, the element is one of the most important elements for this issue is cultural one, which is, it depends on the reality, the sociology of the society concerned. For example, in France it works because the French judges are not revolutionary. They are self-restrained. A sense of measure. It's very French. They normally don't go too far in interpretation, and they know the whole important role of the parliament and of the politics. It's not the same in Brazil. In Brazil, we have revolutionary judges, and they are many, with different and many courts, many levels. with many power, so many power, much power, because all these judges in Brazil have power to declare the inconstitutionality of a law, of a disposition, law disposition, or of terms of a contract, and they do it freely. And it depends a lot, as I told before, of the specific culture concerned by the problem. Thank you very much.
Thank you very much for allowing me a question. I have, and I hope I pronounce your name correctly, Professor Mádl. A question for you. You made some provocative statements. All law is judge-made law, and I understood, and perhaps the value of a civil code is a bit overrated. I'm not going to go into that myself, but I would like, if I may, to cite some words of the drafter of the current Dutch Civil Code, Professor Mádl, who actually in one of his speeches dealt with exactly the question, what makes a code valuable? Is a code valuable? And what he said, and I will translate on the spot, so I hope you'll bear with me. What he said, the importance of a civil code is very hard to establish by experience. If you consult the legal decisions, you will only find here and there some flaws of the legislation. But who would actually would consult only judicial decisions in order to establish the value of a civil code would do exactly the same as someone who would investigate the strength of a nation, of the inhabitants of a nation, by means of merely visiting hospitals. The value of a civil code, he says, only appears if you also look at the cases in which it normally functions, in which it brings questions to clarity without that there is reasonable doubt or judicial interference necessary. So he actually cuts the judicial interference off in order to establish the value of a civil code. And then he continues, and that's the final sentence, that in that respect, a properly formulated system of general rules offers more advantages than a less systemized and incomplete and difficult complex of precedents, sorry, is clear. I hope you understood my translation on the spot, but what do you think about this statement of Professor Mádl?
I give you, to both of you, just a very simple reaction that thank you very much indeed for them, because simply I don't want to go on with such a long-lasting debate. I don't disagree with that. I wouldn't say it at all. I simply want to say that the quality of a civil code, I mean the quality of the rule or the nature of the rule provided in the civil code is not just the same as a kind of regulation of that. And I think that within a civil code that also holds for the Hungarian one, I also could give examples for this as well. I tried to give you examples for different different attempts of the legislator as well. And I simply want to say that I think that the civil code or the written norm in civil law has to be seen together with the court practice and the role of interpretation. And that's what I wanted to mean. I don't really see a contradiction in that. Perhaps I misunderstood something in what you have said, but
the point Myers makes that is that you can even take away the judicial decisions in order to establish the value of a code.
Yes,
you agree.
I agree with that it can be done. I also tried to give you an example of that, like I didn't mean a Hungarian example, but in France was this loi Perouche, because in Hungary the very same thing happened in tort law, but it was not the legislator, but the Supreme Court overruling itself and providing that we awarded this kind of damages in wrongful life cases, but we wouldn't do it in the future because we see that we are alone in Europe. The very same can be done, the very same thing can be done by the legislator or by the court. It doesn't really matter which one want to do that. I think it's also an example, it also happened in Hungary with revising the rules concerning the non-pecuniary damages, but I can't go into the details of that. I will do it in the written contribution, but I can't do it in the moment, where it was the very same what the Hungarian legislator did, that he said that there was a certain prerequisites of awarding non-pecuniary damages by the court practice, and the legislator wanted to say that can't be a prerequisite anymore because the courts are wrong with do that because they limit the availability of this remedy. I think it's also an example for that. That's what I also perhaps my attitude was didn't go into this line, but I also tried to mention you examples for similar like this, what you mentioned. So I think the basic evaluation is to be provided by the legislator.
So now, today, we heard that there are, when we are talking about civil law reform, two basic approaches. Civil code as comprehensive legislation and different separate acts. And I'm wondering, we didn't mention it today, although we are all more or less all law professors here, how these different approaches influence legal studying, legal teaching, and research. Experience from Croatia is that, for example, family law is totally separated from contract law, property law, inheritance law. We even have a specific chair only for family law. We have specialists only in family law. And I think that it is also something what we should discuss when we are talking about different approaches to civil law legislation. And I don't know how it is in your countries. Or, for example, we have also a separated chair for private international law. They are specialists in this field, but I'm not sure that they understand everything about contracts, although they know everything about applicable law in some cross-border cases. My second concern is that in former socialist countries, it's visible that we have a lot of legal transplants, and that I don't know what is your experience, but are these legal transplants sometimes results of specific influence of some foreign associations who took part in reform in a way, or it is something what was decision made by state independently?
Okay, yeah, that's a good point. What does it mean for legal studies and legal research? Definitely, different acts mean also some kind of specialization of teachers and researchers. And we have already talked a couple of times about the problem of family law. It's the same in Ljubljana as in Zagreb. We don't have separate departments, but teachers for family law, for example, are specialized only for this field. And this year is the last year at my faculty of bachelor and master studies. We succeeded to impose the integrated 5-year legal studies as in Zagreb. And one of the consequences of this reform is also that we will separate in future the subject civil law. Today, the subject civil law contains obligations, property, and inheritance, but after this new reform, this will be 3 separated subjects. And I'm afraid that in this case, also the content will be more and more moving in a different way. Yes, this in such case, not to have the comprehensive civil code, I'm afraid that such specialization could endanger the legal doctrine. Speaking about legal transplants, in field of civil law, I think in Slovenia we don't have many of them. On the other hand, in field of, for example, of company law, the Slovenian Companies Act is more or less in field of joint stock company, the translation of German Aktiengesetz. And yes, there are many problems because it's not it's quite difficult to take one institute and put the same institute in different legal framework. It's not so easy just to lift something and put input in the other legal systems. There are so many connections and links, and usually these connections and links to the institute are not harmonized. So sometimes we have a very strange rule which could not be like a puzzle in the picture. That is the danger of legal transplant. But as I said, in this pure civil law, we don't have many of them. But I'm really afraid of another thing: the language of European law, because the language of European directives is very different as language of classical civil codification. And in Slovenia, in my country, the bureaucrats must fulfill their homework to implement, to harmonize the national legal system with European directive. And the most easiest way to do this is just to take the rule from European directive and to put this rule in the same wording in law. And I cannot imagine the mixture of legal language from European consumer protection directives with the language of obligation code.
May I start with the second question? Yes, I think in the smaller countries or weaker countries with more political or structural problem, as Bosnia is, legal transplant or transfer of law played one more important but important role, and I think we have really support, and it could be clear benefit for one country, the expertise from abroad, but it comes for me up to attitude to one countries to this. Our authorities was absolutely passive. It was very important. One organization from country A comes to ministry and said, okay, we will buy a new car, we will buy new furniture for the ministry, and then we can do something in your legal order, really. That I have mentioned that this different influence had a positive result in the field of the security transaction. It's due only to one moment. One organization, and one German organization, was behind all this reform, and these reforms were coordinated. And also legal scholars from Bosnia and Herzegovina were included in this discussion and drafting. Normally, by assessment of the transformation in the former socialist country, it was written a lot of, and I think we mentioned also Professor Harmati. Also, he has research in this field, and it was stated that when one international organization, governmental or non-governmental, drafted some reform, there was not public debate. It was the anonymous domestic expert were engaged without scholars, and it was also relevant how powerful one organization is. For example, this law on registered pledge, which is of American origin, was enacted in the state law, and it's a very clear state law, state level. Bosnia and Herzegovina does not have this competence. Bosnia and Herzegovina is only in this sense comparable with European Union. Only this, what is expressly stated in the constitution, is competence of Bosnia, and register pledge is not mentioned. But the American USAID was behind. No objection, law has been enacted. Then we have very serious reform of the Obligation Act, really drafted from Professor Rüssmann from Saarbrücken with Bosnian and Herzegovinian scholar and expert. And it was a very good piece of legislation. We have discussed it the break. In this moment, it was 2006. The European directives which were in force in this time were very carefully implemented in the corpus of the Obligation Act, and it was refused in parliament since there is no competition of the state level. But Bosnia and Herzegovina has competition which had come for freedom of the small internal market of Bosnia and Herzegovina. Our authorities have never used this possibility. So that I think we were lucky. With this approach of the authorities, we get not so bad result. And then to the codification and the systematic, I'm really convinced that if you teach this as whole, if you study this as whole, it makes sense. For example, Austrian example, where the students have to make exam from general part of law until international private law. Of course, it's a challenging, but it gives a good result. Or not to speak about the German system, which is very, very strict, but also with top result, I would like to say. We have one more problem. Not only that the professor, I cannot imagine that someone can teach whole life only family law, or only inheritance law, or so far. You lose connection to the entirety first. And for the students, and I think we will, the Bologna reform was implemented in the Bosnia and Herzegovina in such a way that we make for each this branch one exam. And students pass exam in the winter semester in Introduction to Civil Law, and when we teach property law and inheritance, they forget it. So that yes, it's a problem. It has really bad impact on research, on teaching, and as final result on the knowledge of the students and future professionals.
Well, thank you. I would like to come back to the legal transplants because I think they are very interesting from the methodological point of view. And my question would go to Professor Juhart. You mentioned that in Slovenia, the German law on joint stock companies was more or less copied. And we know that the German law on joint stock companies has a large chapter on groups of companies, Konzernrecht. And we know that German courts extended the application of the law on groups of companies in a very broad way. They applied on companies with limited liability and hugely further developed that law. My question is, would you apply that law in Slovenia as it laid down in the Joint Stock Company Act, or would you also apply those extensions developed by German courts?
Yeah, it's quite easy. The Companies Act applied also the rules of verbundene Unternehmen from German law, but not the case law from courts. So sometimes our practitioners have problems how to interpret the rules, and in these cases they have to know the German language to look in the German doctrine and German court and German case law. It's very easy. But on the other hand, in a small country, sometimes it's quite difficult because the number of cases is very limited. And in some fields of law, in 30 years, we don't have any case. For example, in concern law, in Konzernrecht, there is almost no cases.
So that's the most easy answer.
Yeah, that's quite easy. And in this way, sometimes it's difficult to assess the success of the legal transplant because it's just too complicated for our society.